According to you, the union can reject a bill passed by both by the houses of the state legislature.
Yes, ma'am. Should it?
The governor has a veto power under Article 200 to withhold.
Using words like veto perhaps are an uncharitable characterization. The governor has the power to withhold assent. And I make bold to say, the framers of our constitution have created a system in which the union can refuse a bill passed by an assembly from becoming law. So, what is uncharitably characterized as a veto, and I'll say why I call it uncharitably characterized. That exists anywhere in the Constitution. Unless we rewrite Article 201.
According to you, the union can reject a bill passed by both by the houses of the state legislature.
Yes, ma'am. Should it is a matter of high discretion. We always say in rare circumstances.
We are not going into question of should it or should it not.
Exactly.
But according to you, the union has the power to do so.
Yes, ma'am. And that is plain from the language of the proviso to 201. So this entire exercise of trying to avoid a veto-like power overlooks that the language of 201 does not admit of any such limitation. Now, if that is the starting point of the debate, and we give up the notion that finding a veto is antithetical or erodes a federalism as envisaged by the Constitution, then we come to very different conclusions. There are two articles which have not been addressed. Are the width of 361 and judicial review. And ultimately, Malad, we all come to they will all lead to the same conclusion. Whether you look at it from the justiciability point of view or you look at it from the functional and the operational point of view of how these articles operate, the conclusion will be the same. And that's what I propose to Malad, put across your Lordship's kind of consideration.
The governor has a veto power under Article 200 to withhold.
Malad, using words like veto perhaps are an uncharitable characterization. The governor has the power to withhold assent.
When you only argue that if vetoes are not anathema to the Constitution.
Malad, I said what is uncharitably characterized as a veto. Malad, I said what is uncharitably characterized as a veto. But it's a convenient shorthand expression. Malad, I call it that's why in my note also I've said it's uncharitably characterized as a veto. Veto has certain pejorative consequences which we don't use for high functionaries. A veto is something you use for personal interest. Nobody here acts in personal interest. Now, to get to where I have.
Sake of clarification.
Yes.
Your argument was that the union has a right to reject a bill passed by the legislature.
Yes.
So whether that power can also be exercised by the union in respect of list 2?
Yes. I'll make it good. I'll make it good.
Even if there is no dependency with the central law?
Absolutely, Malad. Under Article 201, there is no such limitation. Malad, we have always started this with certain preconceived notions. There is a separate 254(2) is a different matter.
What happens to the constitution reserving subjects in list 1 only for the union, subjects in list 2 only for the state legislature, and in the list 3 for concurrent list?
But that is 254(2), my lord, not 201 proviso.
So
There are separate powers.
while reading 200, we have to ignore 254.
No, my lord, they are independent powers operating in independent circumstances. Some of them have conditions precedent, some of them do not. If we start, my lord, stitching up these provisions, we are eroding what the framers of
the principle which know is of harmonious construction.
My lord, there is no disharmony. There is absolutely no disharmony. If we start with a premise that any such stymieing of a bill made by the state is antithetical to the constitution, if we start with that premise, then the disharmony starts. If we read the constitution to understand what was the structure the founding fathers had in mind, then the disharmony disappears. So that's why I start by saying we don't start with any preconceived notion. Let's try and find out what the constitution says. And that's why, my lord, I don't propose to cite any judgment. I invite your lordships to read the article.
Yes.
The first is, my lord, let me cut to the chase. If your lordship pick up 201, and my lord, your lordships have been told this repeatedly, and long reasons have been given. I need to only state it. Each word of these provisions was carefully calibrated. Look at 201. Where a bill is reserved by a governor for the consideration of the president, the president shall declare that he assents to the bill or that he withholds assent thereof. And provided where the bill is not a money bill, the president may direct the governor to return the bill to the house, or as the case may be, houses of the legislature of the state, and with such message as may be mentioned. And when the bill is returned, the house or houses shall reconsider within a period of 6 months. And again, if it is passed by the house with or without amendment, please mark the words, it shall be presented again to the president for his consideration. Now, my lord, and your lordship has seen the language of the first proviso to 200. I don't need to go to it right now. I will at some point deal with the language. The words shall not withhold assent therefrom are conspicuous by their absence and cannot be read in. We would be rewriting this proviso. This defines Indian federalism. And my lord, there is nothing shocking about this. High constitutional functionaries in a democracy are in the ultimate analysis. But a democracy functions by the good sense of the people.
Dr. Ambedkar in his speech of 3rd of November 1949 elaborately expresses about how our federalism works and how it is distinct from the American system.
Correct, madam. And that is very important. If your lordship, the speech has been shown. The essence of that speech was
what he says that except the situations of emergency, states would work within the fields assigned to them, and the union would work within the spheres allotted to them. And only when there is an internal or external emergency, the power shall stand vested with all the power shall stand vested with the central government, so that the country is united and strong at the times of peace as well as war. That is the words he uses.
My lord, that is in a completely, may I, my lord, explain? Unfortunately, in some of the cases also, the understanding of 200 and 201 has become competence centric,
Has become
legislative competence centric.